Yes, friends, welcome back. In our previous discussion, we had discussed about the doctrine of indoor management. That is, an outsider is expected to believe that all the internal affairs of the company is taken care of and then the contract has been executed. In case the internal affairs of the company has some issues or there is some breach of it, then the outsider is protected under the doctrine of indoor management. That's popularly under the Royal British Bank versus Doctrine, or in popular words or in popular case laws names, this would sit right up there as Torcon's rule. Let's see what are the exceptions to doctrine of indoor management. Remember, first we discussed of doctrine of constructive notice. Then as an exception to doctrine of constructive notice, we understood what is meant by doctrine of indoor management, and now we are seeing an exception to doctrine of indoor management. That is an exception to an exception, wherein whatever we are trying to understand now could possibly be understood also as doctrine of constructive notice. So you could probably add these points as doctrine of constructive notice under doctrine of constructive notice as well. Or if it is an independent question as to please explain what is meant by doctrine of indoor management and its exception, the second part of my previous video which discussed about doctrine of indoor management should be written. Apart from that, what I am going to explain now also should be written as a full-fledged answer. Let's see what is doctrine of indoor management, its exceptions. Exceptions to the doctrine of indoor management. First of it, whenever there is an active or constructive knowledge of an irregularity to a particular person, then we say doctrine of indoor management does not apply in such scenario. What do you mean by this? Where a person already knows about the irregularity, whether he actually knows it or there are certain acts which is done which is very clearly indicating that the irregularity has taken place, which is called constructive notice. So if a person has actual notice of an irregularity, or if there is an act done in such a way that it leads him to believe that the irregularity is possible, then we call it as constructive notice. So if a person knows that there is an active irregularity, or he has active notice of an irregularity or a constructive notice of an irregularity, then definitely doctrine of indoor management does not protect him. Check this. Then doctrine of indoor management will not be applicable and the person cannot be protected because he knew about the irregularity, whether actively or constructively, and in spite of which, if he has entered into a contract, then it is his mistake. Remember, ignorance of law is not an excuse. So we continue further. The knowledge to the person could be active or actual or constructive. Then we go on to understand a particular case law which upheld this issue. The case law's name is written here, Howard versus Patent Ivory Manufacturing Company. What is a gist of this case? I have put it here. Let's see what it is. Could not defend the issue of debentures to themselves as they should have known that they should obtain the consent of general meeting to lend the money which is obtained by the company. Of course, this permission from general meeting should have been obtained, or the consent from the general meeting should have been obtained, which was not in fact obtained in the facts of the case mentioned. Now, what is all about this case law? Let's break it up into small pieces and understand it. What it says is, the person who wanted to buy debentures from the company technically is lending money to the company. When the person who wants to buy debentures to themselves, then he should have known that this fact of buying debentures from the company and issuing or giving money to the company should have been approved by the general meeting. That means it should have been taken with the consent of the general meeting. Now the question here is, whether the consent of the general meeting is obtained or not, whether should we treat that as an internal affair. Now, if it is a third person who is buying debentures from the company, yes, this general meeting consent can be termed as an internal affair. However, if one of the persons of the company itself wants to buy the debentures and lend the money to the company, then the question arises as to whether is it a third person who is not required to know the internal affairs. Yes, obtaining the consent of general meeting is an internal affair. Having known the fact that the general meeting has not consented or the consent from the general meeting was not obtained, in spite of the fact which I've just told, if the person has gone ahead and purchased the debentures by giving money, then such transactions cannot be protected under doctrine of indoor management. To put it in simple words, where one of the members of the company has purchased the debentures by lending money to the company. Well, when debentures have to be purchased, consent from the general meeting should have been obtained, which was not in fact obtained. Therefore, we can say, even though it is an internal matter of obtaining the general meeting's consent, it is a person who knew that there was no consent obtained, and in spite of that, he has lent money and purchased debentures. Such transactions cannot be covered under doctrine of indoor management. I hope I am clear about it. Next, similarly in the case of Morris versus Kenson, the facts are similar, but the only twist is in earlier case of Howard versus Ivory Manufacturing Company, we discussed about debentures, whereas in Morris versus Kenson, it is about allotment of shares. So whatever the required formalities of allotment of shares for a person who is already in the company, he should have known the fact that the formalities should have been completed, and in case he knew that the formalities was not completed and in spite of that he goes ahead and does the transaction, then it is at his own risk. Then you can't apply doctrine of indoor management. Reason, he actually knew or constructively knew the irregularity which has happened. In spite of knowing the irregularity, if he goes ahead with the transaction, such transactions is not protected under doctrine of indoor management. That is precisely what is in the first exception. Let us see the second exception, wherein second exception to doctrine of indoor management says, if there is a suspicion of irregularity. In the first one, whether there was an actual or a constructive irregularity of which the knowledge is known to the person. In the second exception, we are seeing something called suspicion of irregularity. Something unusual is happening, something not in the normal course of business is happening. Such a scenario is being discussed here. Let's see what it is. Doctrine of indoor management will not protect who behave negligently. Any person who is acted negligently without verifying, if he has some suspicion, he should inquire it. In case he is negligently ignored it, then doctrine of indoor management will not protect that person, stating that even though it is an internal affair, you had a suspicion. Once you had a suspicion, you ought to have inquired it. Since you failed to inquire because of your negligent act, then doctrine of indoor management will not apply in such cases, and therefore the third person will not be protected. Let's see further. Where the transaction is unusual or not in the ordinary course of business, then it is a duty of the outsider to make necessary inquiry. Now, what is unusual and what is not in the ordinary course of business is depending upon the facts and circumstances of each case. When it is ordinary course of business, then yes, doctrine of indoor management applies. When it is not in the ordinary course of business, or when it is an unusual transaction, then you need to take necessary inquiry protection measures, which if you fail by way of negligent act, then definitely you are not protected under doctrine of indoor management. One of the cases which discussed what is an unusual transaction is Anand Bihari Lal versus Dinshaw and Company. See, observe this scenario. Plaintiff. Who is the plaintiff? Plaintiff is a person who files the case, and defendant is a person who defends the case. So, a plaintiff accepted a transfer of company's property from an accountant Who is an accountant? He is an employee of the company. If a person has accepted transfer of property from a plaintiff who is just an employee of the company, the basic ingredient in this transaction is the plaintiff, that is the third person, should have inquired whether the accountant had the power to sell that particular property. That's precisely what the second point says. Plaintiff was supposed to check whether the accountant had the power of authority to transfer the company's property. If the plaintiff here, that is the third person, has failed to check whether the accountant had an authority, then it is an act of negligence. Now, you may defend the case or you may argue stating that obtaining an power of attorney is an internal matter of the company. Agreed, but listen to this carefully. If it is a director of the company who is transferring the property of the company, then it is understood that the directors have power to transfer the property, because directors are the person who runs the business of the company, who runs the show. Therefore, if it was a director who sold this property to the plaintiff, then the plaintiff could have used the rule of doctrine of indoor management, or he could have used the doctrine of indoor management and stated that it is assumed that the directors had the power of authority to transfer this property. Whereas in this particular case, observe it, it is the accountant who is transferring the particular property. There lies the suspicion. That suspicion is nothing but whether such an accountant has the power of authority to transfer such property. If that was checked, and if he has no authority, he had no business to continue the contract. But here what has happened, the plaintiff has negligently or ignored this fact and did not check whether the accountant had the power of authority to sell the property. Therefore, the court declared this contract as void. I hope the example was sufficient and the case law was clearly understood by you. Next case law is Houghton and Co. versus Northern Louis and Wills Limited. Herein, what the facts of the case states here is, where a person holding directorship in two companies agreed to apply the money of one company in payment of the debt of the other. Now, there are two companies. Let's say in this there is a common director, that is what where a person holding directorship, let's say there was one company A Limited and another company B Limited, for which Mr. X is a director in A Limited also and B Limited also. Now, assuming there were debts to be paid by B Limited, if A Limited has transferred the funds to B Limited for the purpose of payment of debts of B Limited, which is approved by the director, that is Mr. X, who is a common director, he is a person who has knowledge that this is a transaction to clear another company's debts. He should have known whether the formalities to accept the loan from A Limited by B Limited, has it taken place or not. If he is not done that, then obviously rule or doctrine of indoor management cannot protect such director or cannot protect such company eventually if it is turning out to be a bad debt. That's precisely what has happened. Courts observed that it is an unusual transaction, that whether the persons making the contract had any authority to in fact make it should have been checked. Means, now let's say X, who is a director of A Limited and he is a director of B Limited, he has lent money from A Limited to B Limited. X is not the sole person to take a decision. X should have inquired whether the remaining directors of B Limited have taken a decision to accept the loan from B Limited, and similarly, A Limited, and similarly, where X has taken a decision to transfer the funds from A Limited to B Limited to pay the debts of B Limited, whether the other directors of A Limited have consented for it, it is definitely an internal matter, no doubt about it, but the person who is entering into such a transaction is aware of the fact that he should have taken the consent of the other parties, which is failed. There is a suspicion involved here, in which case definitely the act of negligence cannot be termed as valid, and therefore the concept of doctrine of indoor management cannot apply here. I hope the two cases which is discussed was clear in itself. One, transfer from an accountant, which is an unusual transaction, and two, there is a funds transfer from one company to another company, which is not in the ordinary course of business. If it was an ordinary course of business, let's say a banking company transaction, banking company to banking company transaction, yes, I understand that it is an ordinary course of business. But we have provisions in Companies Act 2013 and various other laws of the respective countries that certain formalities needs to be completed if and when there is a intercorporate loans, intercorporate deposits, which you will be reading at the higher level of Companies Act. So, are you all clear with the second exception, that is suspicion of irregularity? If there is a suspicion that an irregularity is going to happen or about to happen, then in such a scenario, doctrine of indoor management cannot be applied. That is, the third person or the person involved in the contract cannot be protected by taking shelter of doctrine of indoor management. Are we clear with the second exception? Yes. Let's go to the third exception. Very interesting to note, very tricky actually. Well, I will try to explain it in as simple words. Let's see what it is. Forgery, wrong signature or signature made by a person of another person. Doctrine of indoor management applies only to irregularities and not forgeries. If there is an internal irregularities, then the third person is expected to presume that all these irregularities have been, regularly taken care of, or rather, if the formalities, whatever was there, which was an internal matter, it is assumed that it is taken care of. To that extent, doctrine of indoor management applies. That means it is talking about doctrine of indoor management applicable to a limited case of irregularities case and not forgeries case. Let us see what happens if there is forgery. Yes, forgery eventually leads to nullity of the contract, that is, contract becomes null and void, whereas we can give that in a example. The best example is in this case. Let's see what it is all about. In Reuben versus Great Finghall consolidated case, plaintiff, that is a person who has filed the case, was a transferee of a share certificate. He is the receiver of the share certificate. That means he's paid money and received the share certificate under the seal of the defendant's company. The defendant is the company itself now. What has happened? The plaintiff has applied for shares and the share certificate was given to the plaintiff in the common seal of the company, but the company is denying this now. Why is it denying? Let's see. The company secretary had affixed the company's seal. Company seal was no doubt affixed, but the company secretary had forged the signature of two directors of the company and issued the certificate. Which means plaintiff no doubt purchased the shares from the company. The company issued under the common seal this certificate, signed by two directors, but not the directors, but it was forged by the company secretary as though it was the signature of the directors. Now, one end, the plaintiff is arguing that these signatures and whether it is a genuine signature or a forged signature is an internal matter, or it is related to the internal affairs of the management of the company, whereas what the courts understood it and explained it is here below. Please check. Plaintiff stand that the signature was genuine or forged was an internal affair and the company should be stopped from denying the certificate. What is the plaintiff saying? Whether the signatures were of the directors or otherwise, that is, whether it is genuine or forged, it is an internal affair of the company's management. Therefore, the plaintiff is pleading to the court stating that please protect me under the doctrine of indoor management. Whereas what the court stated is, that means the plaintiff is pleading to the court telling that please protect me under the shelter of doctrine of indoor management and stop the company from denying the certificate or denying the issue of the certificate. Or should I say that the plaintiff is asking in simple words, asking the court that listen, the signatures, whether it is genuine or forged, is an internal matter, so you should not ask the company to stop giving the certificate to him, or you should ask the company to still give or issue the certificate to the third person, is what the stand of the plaintiff is. But what the courts have observed, it's straight. Let's see what it is. Court said that the Tarkon rule, which is nothing but doctrine of indoor management, cannot extend to cover such complete forgery. Now, please understand the equity involved in it, natural justice involved in it, where the directors itself has not signed it, where it has been forged. Applying the doctrine of indoor management, how can we rectify what has already happened, which is a blunder, which is a mistake? You cannot rectify or ratify such mistakes, which is beyond the powers. The concept is ultra vires transaction in this case, wherein it is beyond the powers of the secretary to even sign a share certificate. In that, if the secretary has forged the share certificates of the directors, forged the signatures of the directors, then you cannot rectify or ratify what blunder has happened. Therefore, courts very clearly have told that you cannot extend the doctrine of indoor management to such an extent which includes forgery. If and when that happens, then natural justice fails over there. Therefore, court very clearly told it is an exception. That is, forgery is an exception to doctrine of indoor management. Yes, friends, this was all about exceptions of doctrine of indoor management. We have effectively concluded Companies Act 2013. In case you have any doubts regarding these topics, please mail me to lohitacademy@gmail.com. I will revert back to you. Thank you so much.